Hi everyone, welcome to School Slay again, and it's me Salamatu. And today we are going to be talking about employers' liability. But before that, if you have not subscribed, please do the needful. And if you have subscribed, please turn on the notifications button so that when we post new videos, you know. Now, when we say employers' liability, what is it? It is that area of tort law that deals with the duty of the employer towards his employee. Okay. In Wilson and Clyde Co. versus English, it was held that the employer's duty towards his employee is in three folds. One, the duty to provide competent staff or competent workmen. Two, the duty to provide adequate tools and materials. And then three, the duty to provide a safe system of work. Let's talk about them one after the other. One, the duty to provide a competent staff or workmen. The employee is going to work in the company of other staff of the employer. So this duty is basically that the employer must ensure that the other people that work with the employee are competent, because their incompetence can cause the employee to suffer injury. And a case that illustrates this is a case called Hudson versus Ridge Manufacturing Company Limited. In that case, another employee was known to be a prankster, okay, and who played expensive jokes on other people within the workspace. Now, in this case, he pranked the claimant, and as a result of that prank, the claimant injured his wrist. The claimant brought an action against the employer, saying that the employer breached his employer's duty towards him when he employed someone like the other employee who was the prankster and continued to work with him or maintained him at the workspace, even though his actions have proven that he is a threat or he can cause injury to other people within the workspace. So in this case, the employer became liable for the injury that the claimant had suffered because of what one of his employees had done to the claimant as his employee as well. Another case that shows this is a case called Black (Butler) versus 5 Co. Limited. So in this case, his estate, he was dead, so his estate was suing on his behalf. So the deceased person was an employee for the defendant, and his job included working underground. As a result, the company employed a manager and a fireman who were to ensure that he was rescued just in case conditions underground became a threat to him. Now, the fireman and the manager, both of them, did not have any expertise in determining, for example, whether there were gas emissions underground that were harmful to the employee or to the deceased person. As a result, when there were carbon monoxide emissions, they could not detect it. And then the employee died. The employee's estate sued the company, saying that as his employers, they owed him a duty to have employed people who had knowledge in how to rescue him. And their failure to have exercised that duty resulted in his death. Okay, and that action was successful. The second duty is the duty to provide adequate tools and materials. And in Davy versus New Merton Board Mills, it was established that this duty is discharged if the employer takes all reasonable steps in ensuring that he buys a reputable make of the tool from a reputable source, and if the defect was latent. In other words, the defect was not easily detectable. In such a situation, even though the tool was defective, the presumption is that the employer had been reasonable or had exercised due care in procuring the tool. So in that case, he will not be liable, even if it has resulted in injury. However, in Taylor versus Rover, it was established that if in the course of using the tool or in the course of using the equipment, the employer discovers that the tool has become defective, in other words, the tool has become harmful, then in that case, he should have withdrawn the tool. A failure to withdraw the tool would then make him liable. Okay, so even though the principle in Davy versus New Merton Board Mills is that once you bought a reputable make of the tool from a reputable source, and the defect was not easily detectable, you are deemed to have exercised due care, and so under the circumstances, you cannot be held liable, even if the defect has resulted in injury. The position or that position is qualified by the position in Taylor versus Rover, which establishes that once you find out in the course of using the material that it has become defective, you must withdraw it. From the point you find out and you don't withdraw it, you would be deemed to have breached your duty. And from that point onwards, you are likely to become liable for the injury that defect will cause. There is a huge debate on whether the employer should be liable if he provided the tools and the employee failed to use them. Okay. At common law, the rule is quite unsettling because in Clifford versus Charlin and Sons, it was held that the employer was liable because even after providing them, he didn't actually ensure that they used them. That was the same position in Bax versus Slew Metals. However, in Woods versus Durable Suits Limited, was held that the employer discharged his duty by providing the materials or providing adequate tools and materials and instructing the employees to use them. If they fail to use them, he could not be liable. In Ghana, the position is quite settled because Section 1183 and 4 of the Labour Act 2003 provides that when the employer has provided and the employee fails to use them, the employer cannot be liable. The third duty of an employer towards his employee is the duty to provide a safe system of work. But Green, in the case of Speed versus Thomas Swift, defines a safe system of work to be the physical layout of the job, how the job progresses, and the presence of notices, warnings, and the issuing of instructions. Now, long and established systems have been held to be an evidence of a safe system. I mean, if you have a system that has worked over time, there is a presumption that it is a safe system, but that presumption is rebuttable. In Kusasi versus GH Cargo Handling, which is a Ghanaian case, the court said that an employee who was a forklift driver being required to look out for himself for any goods that were being sent down from above him while operating a forklift was unreasonable. It was an unreasonable system because while he's driving the forklift, you don't reasonably expect him to be able to look out for himself in that case. So to have established a safer system or a safe system, the employer should have ensured that there was someone who was looking out for the forklift driver while he was driving the forklift in a warehouse. Now, in another Ghanaian case known as Isa versus Mem Timber, the same argument was advanced or the same argument was made to the court, but the court rejected it in this case, citing that it wasn't the practice in the timber industry to employ a lookout man for someone who was felling timber. So in that case, even the long established system of not having a lookout man for the person who was falling timber was safe enough. But then in the previous case, like I said, the court thought that the absence of a lookout man was not safe. So it depends on the circumstances of each case, whether or not it is going to be considered a safe system. Determining whether an employer has breached his employer's duty towards his employee, the court also consider a number of factors, including the nature of the work, the location, and whether under the circumstances it was practical for the employer to have exercised his duty of care. A case that shows this is a case called Cook versus Square D Limited, in which case the employee was sent all the way to Saudi Arabia to go and work, in a building. And as a result of a defect in the building, he suffered injury. Now, he claims that his employers owed him a duty, to have, based on all that we have said, to have ensure that the place he was going to work at was safe. The court did agree with him, but they said that under the circumstances, the employer's ability to have averted that was quite limited. So while an employer owes a duty of care to his employee, in some circumstances or in some instances, the employer would not be deemed to have breached that duty because of the nature of the work or because of the location, among other things. This is where we end today's video. See you again in another video, and I hope you learned something. Bye.